Now, ladies and gentlemen, it's time for the roundtable discussion, the role of in-house counsel in dispute resolution, how to manage and support external counsel during litigation. And for this, let me call upon stage Mr. Manish Mittal, Assistant Vice President, Legal and FCU, Indian First Life Insurance Company Limited. Let's have a huge round of applause, everyone, for Mr. Manish Mittal. The second panelist is Dr. Neera Sharma, Group General Counsel and CEO at Sistema Smart Technologies Limited. Let's have a huge round of applause, everyone. Our third panelist is Mr. Susheel Judd, President and General Counsel at Think Gas. Let's have a huge round of applause, everyone, again. The fourth panelist, everyone, is Mr. Pardeep Khosa, Head of Litigation at Indus KhattarWong, who's also our sponsor. Let's have a huge round of applause. The fifth panelist, everyone, is Mr. Rajeev Goswami, VP Legal at Indus Towers Limited. Let's have a huge round of applause for all our panelists.
Good afternoon, everyone. I know everybody must be hungry by now, but you have to bear with us. It's a pleasure to welcome all of you today for this conversation on a topic that sits at the intersection of legal risk, business strategy, and leadership, the evolving role of in-house counsel in dispute resolution. Traditionally, if we see that disputes were seen as the reactive territory, something to be handed over to the external counsels once damage has already been done. It was the past history we have seen in many companies and in our companies also, but that landscape has shifted dramatically. Today, general counsel and in-house legal teams are not just guardians of legal integrity. I would say they are strategic advisors, risk managers, and increasingly architect of early resolution. So this evolution have been driven by multiple forces, that is rising cost and complexity of litigation and arbitration, then reputational stakes in the age of instant information, and demand from the boards and CEOs for legal strategies that align with commercial outcomes, not just legal wins. Sometimes companies know that they have taken a risk and they have a risk appetite and they really want to do that business. So they differ, like they don't want to really win the legal battles, but they want to create some brand and they want to secure their reputation, even if it is a lost case for them. So today we will be discussing mainly about making strategic decisions about this dispute forums, cultivating early warning systems across organizations, and collaborating with the external counsels to stay aligned with the business priorities, and preparing for the future shaped by technology, regulation, and geopolitical situations these days. So I will not take much of time, so I will go straight to Susheel. Susheel, over the last decade, the role of general counsel has become increasingly strategic. It's no longer just about defending claims. So it's about risk anticipation, reputational management, and aligning business decisions with the business outcomes. So how have you seen GC's role evolve in dispute resolution, particularly in this global environment and when the world is becoming one?
Thank you very much. It's a very pertinent question, because if you see 10 years down the line, the legal department of any organization used to be one man or two men, limited to two-man personnel, and focusing mainly when the damage had been done and the litigation, when the litigation starts. They were hardly involved in contract negotiations, compliances were not very stringent to be followed. And there were some litigations which used to come here and there, and at a later stage, they used to be involved. But we have seen after the economic liberalization and FDI in various sectors coming in, the role of the general counsel or the legal department as a whole has really become very, very important, because the companies have realized that if they don't have a sound in-house legal system, which will kind of give them red flags and which decisions to take, which litigation to fight, where to negotiate, how to draft your contracts to mitigate the litigation, how to correspond with the potential dispute, where you see the potential disputes. So all this gambit of multidimensional role a GC today plays is very different, especially when you have cross-border transactions, compliances, litigation management, and so many, I would say you have labor issues in where you have a lot of factories in the country. So you have to be an expert in, I can say mini law firm where you deal all sort of cases from agreement drafting to vetting to MOU signing to NDAs to arbitration to international arbitrations and to advise on regular, businesses, and also be a business enabler. You should not be seen as somebody who is who doesn't facilitate the business. You have to balance the litigation as well as your business needs, where to stop, where to advise that you should go for litigation or you should go for settlement, so that there's a win-win situation for everybody. As you rightly pointed out, it's no point winning a case if you do lose on commercially you lose. So now a GC or a legal head of a company is a member of the board. He guides in every decision making, whether it is in line with the laws of the country, whether it fits into the regulatory scheme, whether your contracts are as per law of the country, and how do you mitigate the litigation if it comes, and if you have to fight it, how best you fight it. That's how I see it has changed over the years.
Okay, can you tell me how has the relationship between the GCs and C-suite changed in the light of this strategic shift? We have seen now GCs are the part of the boards, or they are invited in the key discussions whenever there is some strategy made. So they have to have in-house counsel there just to make sure that what they are talking is making a sense within the legal framework. So how do you see this shift?
Yeah, it's a very important issue because all the companies have now realized that it's better to be well informed before taking a decision rather than cut a sorry finger later on. So GCs are part of the business decisions. Unfortunately, sometimes they do follow the advice, sometimes they don't follow the advice. They want their business to be on the top and manage the legal affairs later on. But most of the time, I have seen the change now. The regulatory framework where the government, litigation with the government or various stakeholders involved, they do listen to GCs.
Okay, thank you, Manish. So I'm coming to you, Susheel, now, I'm coming to you, Manish, now, sorry. Often legal team is looped in after tension rises, but ideally, GC should be engaged much earlier. At what stage do you believe GC should get involved in a potential dispute, and why is early engagement so critical to the outcome and the cost?
Thank you, Dr. Neera, and everyone. Let's talk to come into this event. I think when disputes come to the management or the business team, I think they should refer to the GC before it becomes a snowball. Because from very first communication, it is very important. If you come to the court of law, the judge will always say, what is your first communication? So I think the legal team should step in at very early stage. Even I am always advocating that if the matter is at bigger quantum, we should always engage the external law firms. Cost is not matter. Please understand this thing. Cost is, if you save 10 rupees today, it may pay you 100 rupees later on. So in my opinion, in bigger matters, we should always involve good legal team and also the external advocate, and we should not look at the cost. This is my opinion.
Okay. Have you seen the early intervention drastically change the course, or or even avoid a dispute? What are your views on that? Like if there is a early intervention by the legal counsels, in-house legal counsels, and they are aware of what is happening in the business, do you think it will make a drastic change in the course? Like what will you take?
Yes, ma'am, indeed, I have a 17-year experience, and in my career I have seen several cases where the GC and the legal team has stepped in earlier, the matter is resolved. Sometimes people are also not looking after the mediation process. If something somebody said, you should go to litigations. But I think the legal team should have stepped in first. They should take the measures, ADR measures like conciliation, mediation with the other parties, especially in cross borders. I have seen the disputes where the cross borders disputes are resolved only by the mediation way. So the litigation has been curved in this matter. So I think you rightly pointed out, legal team and GC has a very important and vital role today's scenario.
Okay, so I'm coming back to Susheel again. So what do you think, what practical steps can be taken that ensure that legal teams are looped in at an early stage?
See, I think it starts with the contract drafting, your contract vetting. You should know, the GC should know his business very well, his sector very well, his regulations, the law governing their sector very well. So unless you know your business, you can't help your management, you can't help your organization in any way. So first of all, you should know the business, you should know your regulations. Drafting stage, right from the drafting stage, the GC should be involved so that they can align their contracts with the legal requirements, and they can foresee that tomorrow this dispute, this clause can cause this dispute. So that's very important. Secondly, if a potential dispute arises or is likely to be seen to come in near future, immediately the GCs or the legal should be involved so that number one, they can assess that what is the risk of, what is your strength and weakness in the potential dispute, where you stand. And in case you want to go for a settlement sort of a thing, suggest those settlements. If you have a strong case, then push for it. So GCs at every stage a very important role to play, especially when you correspond, when a potential dispute you see is like to be, going to arise, you engage in correspondence with the other party. So your correspondence, your minutes are very important because they are the documents which tomorrow speak when you go for dispute. So while drafting those minutes, correspondences, you have to guide the commercial teams and how do you, draft those letters. So I think at every stage, right from contract drafting, the involvement of GC is very important in today's scenario.
Yeah, that's right, Manish. So coming to you, Rajeev. Now you are working in an infrastructure incentive company, and there is a lot of disputes and multiple facets of business also. You are dealing with customers, you are dealing with vendors, and you are dealing with a lot many things. I know the regulator, the compliances. So what are your views? Avoiding disputes in the first place is often best strategy. And what proactive measures can GC take through contracts, training, and policy to minimize the likelihood of litigation or arbitration down the line, I would say?
Thank you, Neera. This is a very pertinent question, actually, in today's times, especially. So when we talk about dispute resolution, in fact, there has been a lot of discussion for over a decade now on alternative dispute resolution, but very few of us have focusedly discussed on dispute prevention. I think that is where a role of a general counsel becomes very, very important. In an infrastructure company like, as Neera mentioned, where I come from, when you are dealing with thousands of contracts which are on a similar nature, there's hardly any scope where you enter into a piece by piece negotiation with the other party. It helps a lot when you standardize these contracts. So mostly you will see, even in the banking sector or telecom sector or infrastructure, you will generally come across these standard contracts. That helps a lot in preventing the disputes. And while drafting these kind of contracts, of course, you have to take care of both parties' interest. If you're only drafting a contract based on one side's interest, of course, the transactions will not go through. So I think preventing disputes starts from when we start drafting the contract at the very first stage. Then also today, in fact, of course, we have the benefit of using techniques like AI. We even have seen online dispute resolution, but these are again going towards a dispute resolution. I'll take a moment again to discuss about dispute prevention. So when it comes to dispute prevention, involving your GC right at the beginning in case you see there is a dispute coming through, using AI kind of technology to even analyze your contracts where, these days we have such advanced tools where AI can actually analyze a contract and give you some of the clauses where, which are high conflict kind of situations, and then you can probably revisit those clauses and come out with something which is, less conflictory in nature. So those kind of things can be delved into. Then again, corporate governance, we don't talk about much about it in terms of dispute prevention, but I think right from the beginning, if you enter into a corporate governance and ethics kind of things, that also can prevent disputes a lot right at the beginning. Another thing is training. We keep talking about it, but I don't see much of the GCs getting into training that proactively, I'll see. Coming from the infrastructure industry again, before this I was in EV industry, before that I was again in the mining and metal, and all of these industries, EVs of course an evolving industry, mining and metals, everybody knows a highly litigious, highly dispute oriented industry these days. So coming from those experiences, I'm saying providing trainings, proactive trainings by the GC and the legal department to people who are working in field helps a lot in preventing disputes, especially in the infrastructure thing. Because the person who is actually interacting with the other party mostly is not a lawyer. And the kind of discussions that happen, they sometimes lead to disputes in future. So maybe these are the few pointers that I have for GCs. One is of course starting early on. Second is proactively taking the training approach of the people who are from the non-legal background. And thirdly, of course, using technology to standardize your contracts from removing the conflicts from the contract as such.
So like when you are discussing any like early intervention and all this, like do you assess whether it is better to negotiate and close the contract or pay something to the other party or go for a dispute and spend hugely on the litigation costs?
That's a very pertinent question again. And as I said, I come from highly litigious companies, in fact, coincidentally. I have generally been a person who avoids, getting disputes or taking disputes to the court of law. So mostly I've been a very big proponent of settling disputes out of court. But nonetheless, it's a peculiar situation of that particular case which will decide whether you want to take it to litigation stage or not. So mostly when things come to that stage where you think that the other party is, of course, hell-bent on unreasonable demands which cannot be settled out of court, then of course you have to take recourse to the judicial route. But otherwise, I'm a big proponent of talking out with the party and settling it out of the court. And in fact, I've seen huge success in this.
Yeah, must be. So I'm coming from to you, Pardeep, like what we are talking, like litigation, arbitration, mediation. Each has pros and cons. So when a dispute arises, what factors should guide the decision around the most appropriate resolution method? Because you are the other side, like you are external counsel. So what do you think? Like, do you guide your clients, like what path they should take? Should they go for a mediation or they have a commercial litigation or arbitration? Like how do you, what are the pros and cons and how you guide the clients and what is your view on that?
Thank you, Dr. Sharma. There are a number of different ways of resolving disputes, and you've outlined some of the principal ones. You can litigate, you can go to arbitration, or you can try to explore settlement through mediation. But the decision as to which option to opt for, it's usually made not when the dispute crystallizes, but when your transactional documents are entered into. So your transactional documents tend to usually provide for litigation or arbitration. In my experience at least, the use of mediation as a prescribed mode of resolving disputes, you see it in some contracts, but not many. It doesn't seem to be quite popular. And so quite often when a dispute crystallizes, your options tend to be limited to what your contract provides for. And at that stage, I think you would have had to consider carefully, in the event of a dispute, do you want to litigate or arbitrate? And there are so many factors that come into play. It really depends on the subject matter of your contract. It depends on what's at stake, and it depends on who you're dealing with. If your consumer contracts, if you're in the business where you're consumer facing, you enter into thousands of retail contracts with someone based in India, it makes absolutely little sense to be thinking about international arbitration. Then again, you don't really want to be litigating those matters given their volume. And so in situations like those, I would think proactively providing for mediation is something that you would want to provide, you would want to think about. You know, on the other hand, if you're a big corporation where you have cross-border dealings, so for example, I think Rajeev spoke about being in the infrastructure space, the construction space, the energy space. The nature of your business and the number of people you're dealing with, that tends to almost invariably be a cross-border element. What that really means is that that counterparty of yours is not going to agree to litigate in India. They would want a neutral mode. And so then international arbitration comes into play. So I suppose the big point is where you resolve your disputes tends to be a question which you need to think about before the dispute crystallizes, at the stage where you're entering into the transactional documents. And I would suggest that instead of thinking about the traditional modes of merely litigating or arbitrating, mediation is something that commercial parties, GCs like yourself, should be giving a bit more thought to, because the upsides are tremendous and the downsides, if any, are quite limited.
So you are coming from Singapore, like how mediation is popular there? Like, is it a popular way of resolving the disputes, or?
I think the short answer is yes, and it's popular because our courts have made it popular.
Okay.
So in Singapore, the rules of court oblige parties to consider alternative modes of resolving a dispute before you commence proceedings. So if you commence proceedings and you go to court, very early on there'll be a case conference, but the registrar is going to ask you, have you attempted some other way of settling this dispute? If the answer is yes, they would want some detail what that attempt was. And if the answer is no, almost invariably you'll be given a direction to write to the other side and explore mediation. So there is a strong push on the part of the courts themselves to have parties, as far as possible, resolve their disputes by way of mediation. And complementing that push by the courts is the fact that you have institutions in Singapore which are designed specifically for this purpose. So for the longest time, we've had the Singapore Mediation Center. Now there is the Singapore International Mediation Center. There is also the Singapore Mediation Convention, which permits the international enforcement of settlement agreements resolved by way of mediation. So what you see is there's certainly an awareness, there's certainly an increasing use of mediation to resolve disputes in Singapore. But it's a move that's been precipitated largely by a push on the part of the judiciary as well as the government.
Okay, that's a fair point, and I think we in India also now pushing a lot to mediation. You want to say something? Yeah.
In Commercial Court Act, we have a mediation process also in India now. If you find some recovery, so you have to go for the mediation before filing a civil suit. So now in mediation, India also becoming a popular, and it is mandatory in Commercial Court Act.
So Rajeev, coming to you, like from AI tools to geopolitical shifts, the dispute resolution landscape is changing rapidly. So what trends, legal, technological or geopolitical, do you believe will most shape how companies approach disputes over the next 5 years?
Sure. Yeah, that's a very pertinent question. Again, on the geopolitical side, we all know, in fact, recently how the geopolitical scene is changing, how the terms in some of the taxation field at least are being dictated by one of the countries and other countries. We all have witnessed that very recently. How do we deal in those kind of situations where global politics, the geopolitical shifts and the global policies are sometimes being dictated or sometimes being changed, altered by just one company? And they are like not some permanent or maybe even long time changes. Sometimes they are very shifting in nature kind of a thing. So it becomes all the more difficult for us to, analyze or maybe predict the kind of changes that will bring in various transactions. So we have to be, very, very wary and cautious of understanding the geopolitical dynamics and bringing those in our contracts wherever they're relevant, especially in the international context or maybe import kind of context. That's one thing. We've seen it. On the technology side, like I earlier said, because of COVID, of course, we were some of the early adopters. Not we, in fact, globally, we were early adopters of online dispute resolution. It got preponed by many years, I will say. There were discussions, but COVID made it possible that almost all kind of dispute resolution came online to our own drawing rooms, which is still continuing in some of the cases, but yes, with more technology, I think it will become more easily accessible to us, and we have to adapt to that. Another thing, other than AI have already talked about, but yes, blockchain, smart contracts, these things are also getting, involved into contracts. Blockchain can actually be used in evidence gathering, in generating a contract life cycle in a more concrete manner, something that cannot be tampered with. So these are some of the technological changes and challenges, both which are being thrown up. I think the legal fraternity especially has to, up its game and understand the technology, especially blockchain, AI, and the features, the kind of tools that AI is, throwing our way, and how we can utilize them or leverage them to the best of its capabilities. On the legal side, some of these changes, again, as I said, like online dispute resolution, and as Manish rightly mentioned, even the courts are insisting now on pre-suit mediation kind of a things. In some of the cases, it has become mandatory, especially in commercial suits, that you have to go pre-litigation mediation within the court premise itself and give a report before proceeding with the actual litigation. So these kind of changes we have to be aware of and make the best use of. None of these things, in fact, I think some 5-6 years ago, there was this huge perception that AI is going to make lawyers redundant or it's going to eat up our jobs. Now probably that debate has already sobered down, and now we understand it's actually here to up our game, it's not to replace us. So we'll become more efficient, but yes, we'll have to up our game, we'll have to learn technology, we'll have to see how it can become our ally in all of these things.
Yeah, and Pardeep, like from your point of view, like how are you seeing technology like AI tool or e-discovery platforms change how disputes are managed? Like, what are your views on that?
My views on that are simply that it's going to make life a lot difficult for junior lawyers. I mean, technology and the use of AI, it's almost pervasive in every sector, business, industry, organization. At some level, you're seeing technology and in particular the use of AI coming in. It's being used to streamline and expedite your operations. It's being used in your consumer-facing products or interfaces. And the legal industry is no different. We've had intelligent document management systems for a long time. In complex construction, energy disputes where you've got thousands of documents, we've had the software to digitalize documentation, pick up on keywords, tag for the longest time. Now things have just gone up a completely different level. Now if you take, for example, generative AI, it's being layered upon your legal research databases. So the sort of tasks which junior lawyers will cut their teeth on, you spend a lot of time researching points of law. You know what they would take days, if not weeks, to come to grips with. AI tools make that possible in minutes. I recently filed some papers for an arbitration, so we researched a certain point of law. It took us about 4 days. And the next day, I think, someone came to pitch me this legal research tool enabled by AI. And having done the research, knowing the position, I just tested by giving to that system the catchwords we were using for our research, and what took us 4 days, that system generated to, I think, an 80% accuracy in a matter of minutes, which means as legal organizations, we can be a lot quicker and we can turn things around a lot faster at a fraction of the cost. And where that's really going to affect adversely, if anything, are the junior lawyers. The need for junior lawyers and the sort of tasks that they are now routinely assigned, AI can do that. So they need to find another way to develop those skills and stay relevant.
So are you adapting your dispute strategy to reflect geopolitical risks also?
I think we have to. We're an international firm. One of the advantages we like to think we possess over other firms that operate within a domestic or national market is we have an international reach and capability. And that puts us, we would like to think, at the forefront or equipped specifically to deal with the modern geopolitical challenges we are facing. So now we would see clients in Asia, in Singapore or in Hong Kong, looking at us and saying, look, Mr. Trump and his tariffs, there's not knowing what's going to happen tomorrow, but we've got issues with our consumers in the US. Or we've got issues with our consumers in Asia who, because of the general economic uncertainty, don't want to take what they had agreed to. And so how do we deal with it? So the query by its very nature tends to involve cross-border issues of law in Hong Kong or Singapore, or issues of tariffs under American law or certain state in the US, depending on what the governing law of the agreement is. So there are certain risks which today's modern geopolitical environment presents, but I think, or I like to think, we are well placed to assist clients with that.
Yeah, that's perfectly right, because there is too much uncertainty around the world today. Like we see, like every day there is a new announcement, and people start working. They are working on one angle, and then the angle changes in the morning, and we started working on some other angle. So, like as a role of the GC becomes more complex and required skills is evolving too. So what competencies and mindset should tomorrow's general counsel should have? So just one pointer from each one of you. I will start with Manish. So what do you think that what expertise and competencies they need to enhance to face the future
They have to stick to the basics with application of AI. Like I mentioned a word, without prejudice. It is a very small word, but in litigation it helps you a lot. Everywhere you communicate without prejudice, that preserves your rights at any point of time. So I think the new generation advocates or the in-house counsels or the in-house legal team should stick to the basics, but implications of AI. Thank you.
So what are your views?
Yeah, so if you are just asking for a one-word solution for this, it's not a solution, of course, but one suggestion, of course, be financed with technology. That will be, that is, of course, the times have already changed. We should have adopted it, much earlier, but now technology is here. It is here to stay. Of course, we at the position of GC and higher rankings, I'll say basics and fundamentals of law we all are aware of. We all know how it works. But yes, if we also adopt technology, AI, blockchain, all of these kind of things, this is really going to be a game changer.
Yeah, what do you say?
Yeah, my suggestion would be that know your business, know your law, know your regulations, always upgrade your knowledge, and be it technical, with the technological advancement, be it AI or new, because what happens that your younger generation may outsmart you with their, know-how in the technological field. So one should always upgrade. That's the key.
So any views from you, Pardeep?
I think I can scarcely do better than to merely try and sum up in one word the sentiments which have been expressed by my colleagues on the panel, which is it's important to be adaptable. And the premise of being adaptable is being up to date, up to date with regulatory changes, geopolitical changes, consumer demand depending on the nature of your industry. There are all sorts of changes in which you operate, so I think the first thing is you have to stay on top of those, but the key then is really to adapt, because they all throw up different challenges, and if there's one word that I had to use to sum up what a GC needs to be mindful of, I think that would be it, adaptability.
Yeah, that's fair enough. And I would like to thank you, all of you, for this insightful discussion. And I would say, to conclude this, role of in-house counsel continue to evolve. And if you, as the Susheel has said many times, like you need to know the business. If you know the business and you know the pulse of your business in which, wherever you are working, as an in-house or as an external counsel, you know the business of your client inside out, then you will become the backbone of that organization. And you need to put some extra effort, and it doesn't take much long to know the client or to your organization. And you are, like, as an in-house counsel, I would say you are not just the problem solver, you are the now business enablers also. So with these remarks, I will conclude this session. Thank you so very much. Thank you, and thank you for the audience.